So please take your seats. We move on to the latter part of our seminar. I'm glad that you all are all here. Some of you may have noticed that there were people with firmly but decisively asked you politely to move back to the seminar room. I know that there would have been so much good discussion going on that we could have missed the second part of the seminar. But let's start with Principal Patent Examiner Mika Inki. Dr. Inki has also made preparations and prepared the panel discussion after the presentation, and he will act as a facilitator and moderator of the panel discussion. Mika Inki will tell you about the principles of patenting AI inventions. It's not a comprehensive, exhaustive list. You need to leave something to the discretion of the patent examiner. That's why I think that he has named his presentation Some Principles of Patenting AI Inventions. Dr. Inki, floor is yours.
Okay, thank you. So my talk is indeed Some Principles for Successful Protection of AI. So I'll first talk about different IP rights that can be relevant for a product, then some principles behind patenting. The same principles apply to AI inventions. After that, I will discuss some specific considerations for patenting AI inventions. And if we have time, I'll shortly go over an EPO Boards of Appeal decision. So, if you have a product such as a mobile phone, you can have various forms of protection. Patents can cover technical components. These can also be covered with utility models in those countries that have utility models, such as Finland, Germany, China, and so forth. But patents can also cover data processing methods, details of the operating system, user interface functionalities, applications, when they fulfill some criteria. Trademarks can apply to company name, name of the product, application or service, logo, startup tone or ringtone. For instance, Alexa and Siri are AI-related product names. Even IBM's Watson, and if I've understood it correctly, IBM uses Watson as an umbrella term for all their AI products, even though they might not have much to do with each other. You can have design rights on the shape of the product or the shape of some visible detail of the product. You can have copyright on software code, user manual, music, images, and of course you can have trade secrets for technical solutions and know-how that can be kept secret. In AI products, these could include cloud-based portion of the data processing. The outside user or competitor only sees the data that goes into the cloud and the output that comes out from the cloud. So your invention is basically your property since you have invested time and money in making it. So is the invention worth protecting so that your competitor cannot collect the fruits of your labor? You should compare this to protecting your physical property. And oftentimes the intellectual property can be more valuable for a company than any individual physical property unit. So patents, designs, and trademarks are investments, and they are integral parts of corporate strategies for businesses. It can protect the company against imitators. They can possibly even increase the market share. You could convince potential investors if you have a patent application or a patent. But even if you're not applying for a patent yourself or not interested in patent protection or other forms of IP protection, you must avoid infringing competitors' patents and IP. And of course, you can use patent information in your research and development. Patent publications include all kinds of technical details. So a patent gives the owner the right to exclude others from using the invention professionally, but it doesn't give you the right to use the invention, because other patents might cover the product. This right to exclude others is given for a limited time in exchange for making the invention public. A patent application becomes public after 18 months unless it is withdrawn. This applies in most jurisdictions. And society has two interests. It wants to promote the development of new and useful technologies by incentivizing inventors, and it wants to make information available to others. Some very old background: the Venetian patent statute was the earliest codified patent statute. It stated that patents may be granted for any new and ingenious device not previously made, if this is also useful. And basically the same sentence exists in various forms in all patent legislations, even nowadays. And the US Constitution states that to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, that Congress shall have the power to promote these things. And Thomas Jefferson is often called the first patent examiner. In the 1790s, he worked in the US cabinet, and all patent applications went through him, but quite quickly there were too many applications for him to evaluate. But he has said that as the right to an invention is given not of natural right, but for the benefit of society, he knows full well the difficulty of drawing a line between the things which are worth to the public, the embarrassment of an exclusive patent, and those which are not. So how to draw this line between patentable and non-patentable? More recent legislation comes from the European Patent Convention from 1973. I'll talk about the European Patent Convention because the laws have, or the practices have been harmonized in Europe, so the same applies even to the Finnish patent legislation. There are 4 basic requirements from EPC Article 52. European patents shall be granted for any inventions in all fields of technology, provided that they are new, involve an inventive step, and are susceptible to industrial application. And of course, there are other requirements, such that the application shall disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art, and that the claim shall define the subject matter clearly. Now, inventive step is often the key question in granting patents. In EPC Article 56, it states that an invention shall be regarded as involving an inventive step if, having regard to the state of the art, it is not obvious to a person skilled in the art. In Europe, we use the problem-solution approach for determining inventive step. And the problem-solution approach has been developed from EPO Boards of Appeal decisions. In the US, they use different rationales that have come from US Supreme Court decisions. And China's 3-step procedure basically corresponds to the problem-solution approach. According to the EPO Boards of Appeal, the correct application of the PSA method avoids hindsight. So the principle is that even simple inventions can be patented if they provide a technical effect and are not obvious. However, after reading a patent application, most inventions may seem obvious. So the key question is, was the solution obvious to those unfamiliar with it? So the basic outline of the problem-solution approach is given here. It basically assumes an idealized or legal fiction about how an invention is made. You start with the closest prior art document, and based on that, the person skilled in the art, using his common general knowledge, starts solving a technical problem. And this may lead to other documents. And then at the end, you have to decide whether the solution was obvious or not. And of course, the problem must be solved. in the claimed solution. Shortly about international patenting, prior or state-of-the-art can be any published document anywhere in the world, even by the inventors. There is no global patent or trademark. But a Finnish applicant can start with a Finnish patent application in English and continue abroad using the PCT system governed by WIPO or WIPO. You get an office action from us or PRH with a search report within about 7 months, or even faster if you used accelerated processing. An international PCT application must be filed within the priority year, and a decision to file in specific countries must be made after 30 or 31 months. And you can also, if you get a positive opinion from us, use the so-called patent prosecution highway to accelerate the processing in other countries, say in the US. If you get a positive opinion from us, you can fast-track your application in the US. You should remember that a patent is worthless if your competitor knows that there is no chance that you will enforce it, or there is no chance that you will sell the patent to someone willing to enforce it in the courts. But by filing a patent application, you may still get useful information about the state of the art. So, next to some specific considerations for patenting AI inventions. Of course, AI can be involved with patents and patenting in many ways. It can be involved in inventing. Already, sets of alternatives can be automatically evaluated. For instance, in chemistry, you can go through various sets of compounds, or in circuit design, you can simulate a large number of different circuits and choose the best one. But when you're using AI, in principle, the set of alternatives can be more abstractly defined, even if you're not talking about a human-like AI that can invent as a human can. AI can also be involved in drafting patent applications. For instance, it might be easy to, or manageable in some senses, to convert scientific articles into patent applications. But that poses some problems, because nowadays prior art has to be filed at least a day before the patent application for it to be prior art. So if you can convert, let's say from ArXiv or some electronic journals, scientific articles into patent applications within the same day, that would pose problems. You could usurp other people's inventions. There are already systems for searching for prior art. You can also, in principle, use AI for assessing inventive step, although that is a lot more difficult. And of course, you can administer patent-related work using AI. But here we will mainly discuss how AI-related inventions can be patented. Now, examiners do not care whether AI was involved in making an individual invention. However, the person skilled in the art can more and more be a team of skilled people augmented by AI. So if the way of inventing starts changing, that should somehow be reflected in at least the interpretation of the problem solution approach and similar methods used in other jurisdictions. So when you're patenting AI in Europe, they are considered computer-implemented inventions, and a two-hurdle approach applies. First, you need to have technical character or technical purpose. So the input data should be technical. It should relate to a physical entity, specific physical entity, and the purpose of the processing should be technical. And it should be more than a mentally implemented process or a pen and paper mathematical algorithm. And second, you need to have inventive step over the prior art. And this inventive step cannot be based on non-technical features. Here you should note that AI methods are basically mathematical algorithms. A neural network such as a multi-layer perceptron is essentially merely a flexible mathematical model with a chosen number of input and output dimensions, chosen internal structure, and associated learning algorithm. And this learning algorithm includes information about how the initial value is chosen. So what is technical? There is no positive definition for it. But as the first paragraph of EPC Article 52 defines what can be patented, the basic criteria for patenting, the second paragraph states certain things that are not regarded as inventions, such as mathematical methods, aesthetic creations, mental acts, rules for businesses, and programs for computers. And paragraph 3 states that the exclusion applies only if the subject matter is completely covered by these topics. But this list is not exhaustive. Similar additional topics are included in the list. So the subject matter in paragraph 2 is not technical as such either. An inventive step cannot be based on non-technical features. Here's a fictitious example. You could have a short claim classifying data using low-level features. But here the input data is not specified and it could be any abstract data. A longer form classifying medical images using a low-level color and texture features using a neural network. Now this could still be performed mentally because a biological neural network is still a neural network, even though the interpretation might seem a bit silly. So here in red you have a couple of parts that are meant for defining or overcoming the first hurdle so that the subject matter is technical, a computer-implemented method for classifying images of skin lesions, and the blue part can provide, possibly can provide an inventive step over the prior art. You need to have enabling disclosure. Oftentimes in AI applications, the authors have scientific publications with more disclosure. So it seems that oftentimes it's not a conscious decision to leave certain details out. The applicant might not have understood that this is a legal requirement. And also the applicants often want to patent the basic outline of the algorithm, say a black box algorithm where you have input data and an AI defined in general terms, and then you get a solution, which is a meta-level idea which is typically not allowable. So the algorithm must be disclosed so that a person skilled in the art would be able to implement it without undue burden. At least one detailed way of carrying out the claimed invention must be disclosed, the whole claimed scope must be enabled, and the level of skill is similar in determining enablement and inventive step. Of course, the claims must be clear also, define the subject matter. They must provide the intended effect and solve the objective technical problem. Otherwise, the claims are unclear or essential features are missing, and the problem must be reformulated. So you should not define the invention using individual features. Make sure that the input data and purpose of the processing are sufficiently defined. Make sure that the processing steps follow each other logically and that they depend on each other. And the allowable claim breadth is up to the examiner. There's a new section in EPO guidelines for examination on artificial intelligence and machine learning. It confirms that the same principles are used for AI inventions as for other mathematical methods. It notes that terms such as support, vector machine, reasoning engine, neural network are usually devoid of technical character. And the claimed invention must involve technical purpose. Here are a couple of examples that include a technical purpose: heart rate monitoring, classification of images, video, or audio based on low-level features. But there is no technical purpose if you're classifying text documents based on their cognitive content or classifying telecommunication data records. This might not be completely intuitive, but this is how the EPO boards of appeal have decided. So the sufficiency of disclosure is often an issue in AI applications and related EPO boards of appeal decisions. So here's the problem solution approach for mixed inventions. Basically, you set aside the non-technical features that do not have a technical effect, do not participate in the solution of a technical problem. Then you, based on the technical features, you determine the closest prior art, And then when you're formulating the problem, you can include the non-technical features as information for the person skilled in the art. And finally, you can decide whether the claimed invention is obvious to the person skilled in the art. Again, this might not be the most intuitive way of doing this, but this is how it's done. You want objectivity, and you don't want the inventive step to be based on non-technical features. So, when you're patenting AI in the US, many of the principles are similar, but the concept of technicality is not used. No technical effect or technical problem. Different principles are used for assessing non-obviousness. Oftentimes, the end result might be similar, but there are differences. For instance, to be patent eligible, the invention must involve significantly more than an abstract idea. So it should not be just an abstract idea implemented on a common computer and communication network. So I know that Folke Johansson in his next talk will talk more about these topics, so I'll just move forward. I'll shortly cover one EPO Boards of Appeal decision. So here's a quite long patent claim that was at issue in the case. So the red part here is method steps for classifying a text document. So the application related to the classification of a text document. Reasons for the decision state that the board states that although the classification of text documents is certainly useful as it may help to locate text documents with relative cognitive content, but in the board's view it does not qualify as a technical purpose. So it solves a practical problem but not a technical problem. And the board agrees that a human would not use the same method for classifying, so it's not just a simple automation of what a human has always done. And the board states that it might also be reliable and produce objective results, but that doesn't matter. Since the mathematical algorithm does not contribute to the technical character, an inventive step can be present only in its technical implementation. But the applicant didn't include details about the technical implementation. Therefore, the board states that the person skilled in the art would have no difficulty in implementing the steps on a computer. So this is basically a way of combining the inventive step and sufficiency of disclosure criteria. Finally, to summarize, you should include a detailed description of at least one way of carrying out the invention. And you should define the input to the algorithm and the purpose of the processing. And finally, you should use a patent agent in drafting the application and claims. That usually produces good results. Thank you. And next, I believe Folke will talk more about these things.